If you've been disqualified from driving by a magistrates court, there are 4 different ways that you might be able to use to try and overturn the ban. 2 of those are appeals to the Crown Court, and 2 of them are procedures in the magistrates court itself. Let's look at them one by one. The first method is an appeal against conviction to the Crown Court. You would make an appeal against conviction if you don't agree that you were guilty of the particular offence in the first place. So, for example, if you pleaded not guilty to drink driving and you had a trial in the magistrates court and they found you guilty, then you could appeal that conviction to the Crown Court. If you were convicted of speeding and you didn't enter a plea but the magistrates found you guilty by reading the papers that were sent to them by the police or the Crown Prosecution Service, then you could appeal that conviction to the Crown Court. So that's an appeal against the decision to find you guilty of the offence in the first place. If you've pleaded guilty to the offence, then it's very difficult to appeal against conviction. The second method is another appeal to the Crown Court, and this time it's just an appeal against sentence. In an appeal against sentence, you accept that you were guilty, so you accept that you were speeding, or you accept that you were drink driving, or you accept that you were driving carelessly, something like that, but you dispute the decision of the magistrates to ban you from driving. If you have been convicted of something that involves a mandatory disqualification from driving, so driving with excess alcohol, driving with excess drugs, or dangerous driving and offences related to dangerous driving, then you can't appeal. Well, you can appeal the sentence, but you can't appeal against the decision to ban you from driving, because a driving ban, unless you have special reasons, is mandatory in those cases. So no point in appealing against that driving ban. But if you've been disqualified from driving as a totter, where you've reached 12 penalty points and you think you should have been able to argue exceptional hardship, or you've been banned for something like careless driving where there's a discretionary disqualification, then you could certainly try and appeal that sentence to the Crown Court. All appeals to the Crown Court, whether they're appeals against conviction or appeals against sentence or both, are rehearings of the case. So the Crown Court will look at the case again from the start, and they can either impose the same result as the magistrates, they can impose a more serious result, or they can impose a less serious result. If you lose, you could also get additional costs imposed against you for the prosecution. The third method I'm going to talk about is making a statutory declaration. Statutory declarations are used in cases where you didn't know about the court proceedings at all until you found out about them after you'd been found guilty and maybe after you'd been sentenced. So for the most common scenario is where somebody is convicted after a postal charge, but the postal charge has been sent out to the wrong address, or the postal charge has been sent out to the right address, but you never received it in the post. If that's the case, if you genuinely didn't know anything about the court case at all, you can make an appointment with the local magistrates court, make a statutory declaration. That will get rid of the case, but it will just rewind the case back to the beginning, and the magistrates will look at the whole thing again. The last method I'm going to talk about is an application under section 142 of the Magistrates Court. You don't need to worry about remembering the section number, but that's a case where the magistrates have made a mistake, or they need to correct an error, or they can correct something that's happened in the proceedings that needs correcting. They've got quite a wide discretion. Sometimes you can make an application under that section for the magistrates to look at the case again. There are various different examples. One of them is if you've written in with mitigation, and that letter of mitigation never found its way before the court, then you could ask them to look at it again in light of the mitigation that they didn't hear about. Mitigation or mitigating factors are factors that make something less serious and might cause the magistrates to reduce the level of sentence. So those are the kind of things that you can ask the court to look at under section 142. All of the methods I've talked about have various procedural requirements and time limits and notices to be served and ways that the cases need to be dealt with. So you might need some legal advice about that, or the court office might be able to help you out with the basics. There is one other method I'm not going to go into now, but that's going to the High Court. So you can sometimes judicially review a magistrates court decision, and there is a process called an appeal by way of case stated, where the magistrates have got the law wrong. it's quite complex, and it's not something that there's time to go into in a short video like this, but you should be aware that in extreme cases then you can go along to the High Court and ask them to look at the magistrate's decision.